this number.
Hey, you're recording.
You've always
We're on.
always want to go to Easter Island, see the heads, you know.
We're rolling?
Yes.
Okay. Let me call to order the Town of Loxahatchee Grove Special Magistrate hearing for today. Today's Wednesday, June 10th, 2015. That's about 9:40. And let me, I guess, start by swearing in. Well, why don't we do this before I swear witnesses? Why don't we go around the table, everybody identify themselves so we have that on the record.
Okay.
Todd McClendon.
Andrew Bauman, Lewis Longman Walker, representing Larry and Maureen Lefkowitz. Larry Lefkowitz?
Beverly Two and Taylor, Code Enforcement Representative to the Town of Loxahatchee Groves.
Russ Sullivan with Code Enforcement.
Michael Cirillo, Town Attorney.
John Ryan, A Road.
Ron Gerald, Vice Mayor, Town of Loxahatchee Groves.
Okay. I guess we're going to have witnesses. Do I need to swear
I don't know,
witnesses?
maybe not.
I'm not
because
sure what we have scheduled. This is shown as a status update. Is that what it is?
That's what I asked to schedule it as
Okay.
for you, to basically to get your feel or direction of how you would like to proceed with this case. Unless anything objects, I'm just going to go through the chronology. You know, this is a case you had entered an order in April of 2013 relating to two violations: a conditional use violation and a noise violation. There was a compliance date given of May 10th, 2013. To come into compliance, there would be a fine of $200 per day. On June 19th, 2013, there was a hearing set on a compliance, whether it was in compliance with your order. Prior to that hearing, Mr. McClendon's counsel had filed two motions. They filed a motion for rehearing of the April 2nd order, which you had denied, and then a motion to stay the enforcement proceedings, which hadn't been ruled on by the time we got here, on June 19, 2013. During that hearing, there was evidence presented on compliance, and there was an argument made, but there were 4 sound readings that was presented to you, one of which exceeded the noise thresholds of the code. There was testimony taken from Mr. McClendon as well, as I believe, and then there was, again, legal argument, and it really related to what to do with the case, because there was an anticipation of an appeal being filed.
Or an appeal was pending, I think, or about to be filed. And that was, you had Greg Kino at the time, right?
Correct.
Okay.
Yeah. So you entered an order granting the motion to stay. The appeal was filed. So there was no order entered based on everything that happened at the hearing, including the fact that you had taken all the testimony evidence. No order was entered. The appeal was subsequently dismissed. However, shortly thereafter, there was a federal lawsuit filed. So my advice was to not proceed with anything until we got some sort of resolution of the federal lawsuit, and that had recently, the federal part of that case is recently concluded. And so we're back here 2 years later, almost to the day, to see how you want to proceed with the case.
The appeal was dismissed?
The appeal was dismissed shortly after it was filed.
Yeah, I know.
Based on time.
Yeah, there was an issue of whether it was timely.
Yeah, so the merits were never reached, but the appeal was dismissed on jurisdictional grounds.
Okay.
And so, you know, it's really up to you and how you want to proceed. You know, we have copies of the exhibits, including we can provide you with an audio disc of the hearing that happened in June to enter an order. But really, that's how we wanted to see how you wanted to direct us to do it.
Is it the town's desire to proceed with imposing a fine?
Yes, we'd like an order entered based on the evidence and testimony that was presented back in June of 2013.
Okay.
And you hadn't indicated what you were going to do, how you were going to rule. You just you allowed us to make the record at that point and then entered the stay, so no order had been entered.
Okay. And those were the exhibits that were...
Yeah, and you know, absent objection, what I was going to do is provide to you, when our copy has already been provided to Mr. McClendon, the 5 exhibits that were entered
Okay.
at the hearing. And I believe we do have audio tapes of the hearing. Is
Yes.
that audio or video?
Audio.
Audio of the hearing, if you would like to take
Yeah, that would probably be helpful since it was 2 years ago.
Thank you. And then also, just for today, we'd like to put in proof of notice and service into the record for today's case.
Okay.
Copy has been provided to.
Would it be the town's, and I'll let you respond here, whatever, is it the town's position that the fine should be imposed back from the date of original compliance?
No, the fine was $200 per day
Yeah.
for each violation. We had taken noise readings, 4 noise readings, one of which indicated a violation. It was actually the morning of the hearing on June 19th.
Right.
So to say that you could get a daily fine, I don't think, obviously you're the one who entered your order.
Yeah.
But I would feel that this type of violation would be $200 for each documented time it exceeded the town, because otherwise you're dealing with fining on a day where the noise reading did not violate the code.
Right. Yeah, that's one thing that sort of, and I appreciate that comment, one thing that sort of troubled me about this, because you could imply the noise is there, but unless there's proof the noise was there, you know, by sound readings, I don't know that it's proven that there was a violation on a particular day. Let me hear from Mr. McClendon, and I don't know what if anything you have to add.
Well, I do. I think we're in agreement on some things. The town has recently taken the position that agriculture is preempted by state law. Florida Fish and Wildlife has the exclusive authority to regulate possession and care of exotic birds. Are we in agreement on that?
Well, the conditional use part has been receded from by the town. We've entered an order repealing the conditional use. So we're only dealing with noise issues. And I guess on that, I'm not agreeing that they're preempted, but on the conditional use, which was one of the 2 violations you had, the town has since repealed the ordinance on conditional use based on the FWC preemption.
Okay.
Okay.
We've both educated ourselves quite a bit in the past couple of years here. I have come across and found out that local animal control is Florida Statute 828.27. And it lays out what animal control is, and it specifically talks about sound from animals and the necessary criteria to bring somebody to any type of fine and whatnot. It specifically states in here that you have to go by this statute when it comes to animal control. Therefore, I don't think the Unified Land Development Code complies with the requirements in here. Talks about a citation, all the exact criteria that needs to be on a citation. That was never given. I also do not believe that Two and Taylor has been authorized to do animal control, which this specifically states they have to be authorized to do animal control. I don't believe this is the proper jurisdiction here at all to do this. I believe this should be, anything with animal control should be handled in circuit court. There's also a Florida Animal Enterprise Protection Act that's in the same statute that protects animal enterprises from being any economic damages and whatnot, and it actually becomes a felony if the damage is high enough. So I feel that if the town is going to get an order against me that says I need to downsize my enterprise and restrict my enterprise, that's going to cause economic damage, and based on this statute here, that's going to be a felony for the town. I don't know the town's position on either one of these. I don't know if they know the position on either one of these. I have in front of me also this cost recovery sheet that was given to me. I'm kind of confused by it because I was also provided this memorandum that basically says that the majority of costs are not recoverable. However, for some reason there were certain costs that they felt were recoverable, and I'm not sure how it was based on, you know, some of those things being recoverable and some of them not. So I'm not sure about that either. So, but I was not prepared to argue the cost part today, as I thought the cost was going to be minimal, meaning you know, basically that service notification magistrate hearing, you know, any kind of, small cost like that would be recoverable. So I wasn't prepared to argue this $836 that they're asking for recovery. And since this is a status update hearing, I'd like to have another hearing for a fine cost recovery specific to this, since this is new evidence that's being put forth today.
Okay. Is the town pursuing the cost aspect today?
Yes, and when you're ready, I'd like to respond to the two legal arguments.
Okay. Anything else you'd like to add?
Not at the moment.
Okay.
The first thing is, as far as the Florida Enterprise Protection Act, there's nothing in the order that reduces the number of birds. There was, when you did your stay order, there was conditions on the stay that you would agree to reduce the number or whatnot, but that was a condition you had placed on the stay, but we're not looking to reduce any numbers. We're looking, I guess we're just looking at compliance with the noise ordinance. And as far as the animal cruelty control, what I would encourage you to do is read this paragraph 7, which is the operative section of it, and it's one of the more poorly written statutes that I've ever seen. But my view of that, and I had looked at an Attorney General opinion that talked about something akin, that looked at this statute, that this prohibition or this conflict here only relates to allowing us to put on criminal violations for noise if we do it a certain way. It really doesn't have to do with what we did here with code enforcement. You know, it says nothing in here shall prevent any county from enacting any ordinance relating to animal control, which is identical to the provisions in this chapter. No county ordinance relating to animal control shall conflict, which I don't believe there's anything in here relating to noise or any other state law. Notwithstanding any sub-provisions of this subsection, the governing body or municipality is authorized to enact ordinance prohibiting or regulating noise from any domestic animal violation which is punishable by $500, and it says this subsection shall not apply to animals on land zoned for agricultural purposes. Well, if you take out this whole subsection, it says nothing contained in here shall prevent us from doing something, and that we're allowed to do a criminal section, and you take out this, or criminal infraction, and you take out this whole subsection, you're left with basic home rule authority to do something. It kind of, that's why it's really a convoluted, poorly written statute, so I don't think this prevents us from doing anything. The last thing I would point out is that, you know, you had a hearing, you entered an order of violation. Now, I understand the appeal was dismissed for jurisdictional grounds, but, you know, that's what happens when you miss out on a timeliness. These arguments as far as the legality of your order should have been made at that time, and in fact, there was extensive arguments made about the Right to Farm Act in that record. The opportunity to have that addressed is lost, and so now you're just dealing, you have an order that's in place, that's legal and valid, that provided for a compliance date for noise. You're asked now to look at whether your order has been complied with. And so we would say that although these legal arguments may or may not have to be addressed at some point for purposes of today, you have an order that was entered finding a violation, had a compliance date, and you need to look at the record and determine how to proceed with that order. As far as the cost recovery, in the materials that were provided to you in June of 2013, there was a cost recovery table that was put in that saw almost $3,000 in cost recovery. Okay. What we did with this information provided to Mr. McClendon this morning, we have extra copies of that.
Was there handed them to you?
Handed it to me. Oh, here they are, I'm sorry. Is I had, at the town council's request, had done a memoranda to outline what we could recover in these proceedings, and it's the cost of prosecution. So I had asked our code officers before we got here today to refine this list to be consistent with my memoranda, and so the requested cost recoveries were reduced from $2,790 to $836.50, and I would also say, based on my review this morning, that the $157.50 for today's hearing and the $4 additional cost would not be, because neither one of those had to do with the prosecution of this case. It's for today's hearing.
Okay.
So-
Do I have the,
No, I'm gonna provide you
Okay.
a copy. I'm gonna provide Mr. McClendon a copy. I just gave you my blue copy, that's the one we put in. So, we don't think there's any, issue or prejudice to, rather than just say, here's our table that we were put in June, go rule, to provide you with what I believe to be a more legally defensible table for cost recoveries, which is less than a third of what the town had originally requested back in June.
and what you just said is the entry for June 9th should not be there.
I think it's fair to take that off and the $4 off. That's what
Okay,
I'm
so the last two entries.
So, again, that's where we're at. Perhaps you want to take everything under advisement and issue an order when you're ready. If you need to have another hearing, you can let us know, we can schedule a hearing.
Yeah, let me look over things for a rule, and by then I'll have a chance to decide whether I need to hear more. But just so I understand the town's position, you're really asking, though, that there were 4 noise readings, one of which showed in excess of the noise limits.
That's correct.
So you're just asking for a fine for 1 day?
That would be what we've demonstrated to you in the record.
Okay. Yes?
May I make
Sure.
argument, Your Honor?
Yeah, oh, thank you, okay.
I mean,
Well, you know, he's the complainant, so I want to be sure that we don't create anything of a record here. So, if you want to hear from the complainant's attorney, you're more than welcome to.
Yeah, I'm not taking it, yeah, I'll hear from the attorney. I'm certainly not gonna hear any more evidence, but yeah.
not presenting
Sure,
any evidence, Your
Sure.
Honor. Your Honor, Your Honor's order entered back in April of 2013. In finding of fact 18, based upon the testimony of a number of witnesses, including Edward Duggar, who was the noise expert, paid by the Lefkowitzes, who testified at the hearing, provided you with evidence, and you made the finding that, quote, the uncontroverted evidence presented by the town proves by preponderance of evidence that the respondent's use of the property regularly results in sound levels in excess of the limits permitted by section 50-010 of the town code, and citing exhibits and testimony. So your finding of fact was not that this is somebody played their stereo too loud on a Saturday night, that this was a regularly occurring event in the conclusions of law, citing the barking dog case, Ray versus Flynn. You determined in the 3rd paragraph of the conclusions of law that given the totality of the evidence, it's concluded that the respondent's use of the property for agricultural purposes constituted a nuisance, since the established date of their operation, and cited where you got that evidence and made that conclusion from. The issue that we have, Your Honor, is that at the conclusion of your order, in the underlying standard paragraph, that is the quote, it is the responsibility of the respondent to request an inspection of the property as soon as compliance is achieved by calling the town code compliance officer at the number here, town clerk, contacting the officer at the stated address. The onus is on Mr. McClendon to take your order, which found that on a regular basis, these levels are being violated and that a nuisance is occurring, to do something and then to call folks back and establish that it's no longer a problem. That has not happened. That has not been presented. There's been no further noise study. Mr. Lefkowitz shouldn't be required to keep calling out a noise expert to conduct the study. The study is, you know, the noise is on an intermittent basis. Things go off for a few minutes, and things may be quiet for, you know, a couple hours, and they go off, and we're calling code enforcement out there, which we keep doing ad infinitum to get them out there while the birds are going and turn on the sound meter, is putting an unreasonable burden on Mr. McClendon. Mr. Lefkowitz, especially when you found that based upon the evidence presented to you at the hearing, uncontroverted, that this regularly happening. So the issue we have, Your Honor, is that you entered the order, and you're supposed to now determine if something's been done to bring the property in compliance. We haven't heard that anything's been done. We're not here to present evidence, but if it's necessary, I guess we'll have to present evidence, but, you know, it would be our evidence if presented at a later date, that it's still a problem, it's still going on, it's still happening. And the burden is not on Mr. McClendon to come in here.
Mr. Lefkowitz.
I'm sorry, Mr. Lefkowitz, thank you. To come in here and establish that. It's the burden of the respondent to say, hey, whatever the violation was, I did X, Y, Z, cleaned it up, called the town, they came out, checked it out, whether it be another 3-day noise study or something like that, and we're good. None of that's happened.
I'd like to respond to that real quick.
Sure.
I don't see it in here, but there was a stay of that order that was put in advance.
Yes.
I don't
Well, I don't
see
know if it
that-
wasn't here, but there was a stay.
I don't see that in here, and that stay is still in effect, as far as I know.
I don't know, well, that's why we're here.
Exactly.
The appeal, yeah,
Exactly. So
you know.
the argument was, there was an order of finding violation, and I should have complied with this. However, I should have been complying with the stay order, not necessarily the original order.
Well, I mean, I think that we're here to have you determine how you want to proceed. My view would be the stay order was mooted when the appeal was dismissed, but that being said, you know, you entered the stay order yourself, you know, so.
Well,
it's your
certainly,
order.
certainly I would agree with that. The stay would have logically ended. You know, what I wanted to do was give you a chance to pursue your appeal, and you had that chance, and I know it was filed late, but, so the stay, I think, has, and I can indicate in an order that the stay's order is lifted or expired, or whatever the proper terminology is. Okay. Do you have any response to Mr. Bauman's comments?
No, I had indicated before my position on what I thought your order, but your order, again, that's why we were here.
Yeah.
You know, it's your order, you entered it. We had presented a case to you back in June, so in June of 2013. So, you know, if you feel you need to have another hearing with noise readings and whatnot, you need to tell us. If you want to take this information that was submitted, updated cost recovery, review it, you know, independently and enter an order. If you want to set another follow-up hearing where you want to announce something or give us different direction, we just needed to get this matter back before you.
Okay.
To bring it to where it's leading.
Is there a reason why the stay wasn't put in here?
Because of, you know, the order of stay, you mean? Because all we did was put back in the evidence that was presented, and I know that the rehearing was put into evidence. I don't know that the stay was, the motion to stay was put in, but the order of stay, we did not. We can provide, you have it.
Yeah, I have a copy, and I think it was entered,
That's why
I think it was
wasn't-
entered after the hearing, which
Yes,
is
it
why
was.
it wouldn't have been part of that record.
The intent was just to provide him with a copy set. It was put in June of 2013.
Gotcha.
Well, let me address the cost thing, and then I'll circle back to the one other issue Mr. Baumann raised. These costs are all from 2013 practically, so I don't know that there's any problem with moving forward with them. I don't know if you have any objection to them. They were items that were, I guess, were put in as part of the record back at that hearing. The noise meter readings, why would that be taxable as a cost?
Because that's a special cost that was needed for evidence for enforcement, because the noise readings were necessary in order to demonstrate the violation. And those were the noise readings that were taken prior to the order, the April order. Those were not the subsequent.
Right, these were all
readings.
pre-hearing.
These were pre-hearing, before your order of violation. So those were necessary to show the violation.
But actually, on one of the four, I was in violation. The
Oh,
other
no.
three, I was not.
None of those four are on this. All these predate your April hearing we did not, none of these reflect the hearings that were taken in May and June of 13, which are in here.
Do you have any comment as to the costs?
I don't think they comply with state law. I wasn't prepared to argue it today, because I thought we were on a different page, but it is what it is.
Okay. Let me go back to the, if you want to call it the continuing violation issue. It's a problematic case, I think, with noise. It's unusual. And I don't know if anyone wants to submit any law to me, and I'll ask Mr. Baumann this perhaps as an interested attorney or representing an interested party. I mean, it would seem to me, unless there's law otherwise, that what the town has proven that there was a noise problem on one date is sufficient to impose the fine. Now, on the other hand, I understand your point that it's common sense, the noise is still there, okay? But as a matter of proof, I don't know that I can rely on common sense to say there's been a violation at Mr. McClendon's property every day since 2013. I would think there would need to be some level of proof, unless there is some case law that would support a finding that, hey, this noise was such that there's no evidence that it changed, and therefore we don't have to prove that it's ongoing. I don't know if there's any such law out there, and maybe I didn't explain that well, but yeah, I think you understand my issue.
I understand the argument that, it's the respondent's burden to, in the orders that says, you're required to come out and do an inspection to verify.
Yeah.
A noise order or say a parking type intermittent violation, kind of that standard routine doesn't really work very well, because that person can very well just call you out and say, hey, the truck's not here. Come and look, and then you write it off, and then the next morning the truck's been there every day, but at the time they called for the inspection, you wouldn't know. It's not like a situation where somebody's not cutting the grass, or they're not cleaning a lot, or anything like that, where you really know from the point that you had the order to the point where it was actually cleaned and they called you, that it was there the whole time.
Right.
So that's what brings a unique challenge with trying to enforce these types of what I would call intermediate type violations.
Yep.
And so that's why I think your order is in essence almost like a cease and desist type thing. And if there's an order, if we come in with more sound readings, you've got an order that says $200, for each day.
Now, I don't think, and this gets to repeat violations, I guess there would be no finding of compliance with the original order, or is there? I mean, is that an issue to where it would then come back as a repeat?
I think you've got an order that says $200 a day, and so we do one day. So if we come back again, you're just going to be under that order.
Okay.
That's my view.
Okay. Yes?
May I ask a question of Your Honor? If he has to comply and provide evidence that he's complied as this order is in, and evidence is then presented, perhaps by Mr. Lefkowitz, perhaps by the president of the town, that the noise is still there, and testimony is given that, from say the Lefkowitzes, still here, nothing's changed. I mean, I don't understand, while it is like the parking scenario a little bit, you can't just look and go, ha, he did something. There's no evidence here that he's done something.
Now, I think though, and
He didn't move the truck, he didn't mow the lawn or whatever it is.
Yeah. I think though, the language in the order, and I understand what you're reading, and I understand the sentiment of it, that language is more or less from the typical code enforcement case, in the sense that, property owner, don't comply, but don't tell us about it, and then we don't know what to do with it. But call us out and let us look at it after you've taken care of the problem. This being the intermittent problem, presents different issues. I do think, though, I mean, despite the language in the order, I think that it's the town's burden of proving non-compliance with the order as opposed to Mr. McClendon having to prove that he didn't comply, or he didn't comply with the order. I don't think that shifts the burden of proof. You know, I think the first step is did the town prove the violation? I think they did. Second is a violation ongoing. I think that again is a burden of proof issue for the town, that they would have to prove it as opposed to the property owner having to prove a negative. So I don't know if anybody has any thoughts on whether there's any law out there that would support an ongoing finding of violation. I don't know if that exists. If it does, I haven't seen it. Not that I've exhaustively researched it.
Your Honor,
Yes, sir.
since this is not an evidentiary hearing, can a party that's observed the process and the presentation of evidence and has recently read over the order, can I make a logic comment?
You may. Yeah, I'll hear from you.
All right. The situation that impressed me in the hearing process was that Mr. Lefkowitz, recognizing the intermittent proof problem, hired an expert who did a 3-day continuous study. And that study substitutes dramatically from having to call a code officer to come out and make a particular noise reading. This is an expert who provided equipment that would record sound levels on hourly intervals and document multiple violations. And I think the evidence that was presented showed over that 3-day period that there were 26 total violations and a smaller number where they were dramatically exceeding the allowable noise levels. It would seem to me that rather than just say this is a conundrum, that the respondent ought to be put to a test of either he's in compliance and he ought to pay for a 3-day study to prove that, or as per your original order, you gave him about 4 weeks to come into compliance, and he should pay for a study at that time. And that removes the conundrum of having to have some party, whether it's the respondent or Mr. Lefkowitz, call the code enforcement officer to come out there with his noise meter, because this is calibrated record, continuous, for a 3-day period. And I think that if there's any logic to a noise ordinance with these kind of situations, and it being a noise problem with the county and with the town beginning in 2006, that it would be warranted to have the respondent pay for a study now or at the end of your original 4-week compliance period, and that would be the basis for either compliance or non-compliance. And I think the cost of the study that was mentioned was, I don't know, between $1,200 or $1,500. So it was not a prohibitively expensive study, and it would be done by an expert who had already been recognized by the court as an expert. And I think that rather than just let this thing devolve into meaninglessness, and I certainly don't think that the evidence that was presented showed it was a one-time violation. I think that the evidence showed that it was, and I think you even recognize this in your comments, that it was continuous and repetitive. And I think if this thing's going to be brought to a realistic conclusion where the town's noise ordinance makes any sense to protect a resident who's had his property value damaged and his quality of life damaged, that it really ought to have a more logical way to proceed at this point than just say, well, let's look over the past record and think about a 1-day fine. I think it either ought to be brought into compliance and proved it's in compliance, or it ought to be looked at as a serious continuing violation.
Okay.
And that's logic.
Any comment from anybody else? And I'll
Real
wrap up.
quick. Last I checked, we're in the United States and I was innocent until proven guilty. These two's position is I was guilty one day and I'm guilty every day from there. And I need to prove my innocence. I don't need to prove my innocence. They need to prove I'm guilty. The town, you know, I'm not conceding to it, but they've proven one day that I'm guilty, not every day since.
You know, the issue we've had for most of the time since the hearing is, of course, you had to stay. You know, so, and, you know, as you can see from the cost recovery, each time the town goes out there, it's a cost to the town. And, you know, I agree that getting beyond the scope of what your order is and what we're asking you today, because in essence, we keep coming back to the fact that you need to tell us how you want us to proceed in this case, given what happened back in June 2013.
Okay.
I'm not disputing the fact that there was a problem, that there could remain to be a problem there. It's of long-standing nature. I'm not sure that whatever you do, whether you put in an order that says no fines, or you put in an order that says $70,000 in fines from May 10th to today, give or take, is going to address an issue that needs to be addressed. And hopefully one of the things that can come out of bringing this back up is to have some sort of fruitful ability for the two parties to try to work things out. I'd rather not have the town involved in years of litigation over this. And so my reason that I'm making the positions I am is because I think they're legally defensible should this order be appealed. And so, anyway, I think that what you ought to do, this is my view, is you've heard a lot of argument from myself, from the respondent, from the complainant's attorney, and from Mr. Ryan. And take it under advisement, give us an order, tell us how you want us to proceed. If you want us to come back again after you've reviewed it, we can come back again in July sometime. It's up to you. You know, again, that's why it was only stated as a status conference, because it's your prerogative how you want to proceed. You heard the evidence, you entered the stay order. We weren't at liberty to just bring it back and say, enter an order today.
Okay. Sounds good. I will do that. I'll take it under advisement. I think that, you know, to address your comments, sir, that a lot of what you're asking makes a lot of sense, but I think that's probably beyond my authority as a magistrate under Chapter 162. I mean, maybe a judge could order that, but, you know, I'm not a judge. So anyway, I will take it under advisement. I'll enter an order. Whether the order reschedules or whatever, we'll see how it plays out.
And just so we can make sure of the record, we did provide you an audio of the June
Yes.
19th, 2013 hearing. The yellow page is marked Exhibit 1 is just notice, proof of notice for today. And then we provided you the original exhibits from the June 19th, 2013 hearing.
Right, and I do have the cost.
The updated cost recovery, and then the two statutes provided by Mr. McClendon.
Right.
Highlighted by Mr. McClendon.
And I'll make all those part of the record as an exhibit, as exhibits.
Any objection, any of that?
I have to reserve an objection for the audio,
For
because
the
I don't
audio.
hear it.
Okay, well, if it turns out the audio is not correct,
Sure.
we'll hear.
Or if it's the wrong hearing or something, I'll let y'all know.
I'm trusting my code officers, but do you have?
Did you listen to it?
No, I haven't. Can you take mine?
Sure, sir.
Yeah, I can get
I
another
made
copy.
sure when I made sure it was right.
Bev, would you get me another copy of the audio? I gave Mr. Bauman mine.
Oh,
Do you need a copy to
well, I
make
was
a
gonna
copy?
make a copy of this. That way
How
we
long
know.
would it take you?
I mean, I don't need it.
Okay, let's go.
2 months?
2 minutes.
Okay, I guess we're done, nothing else on the
There's
agenda,
nothing
right?
else on the agenda.
Okay, so we will adjourn, it's about 10:20.
Thank you for
Thank
your
you.
time.
Janet,
Thank you, Mike.
Thank
you
you.
wanna get this off?
If the judge is concerned about wiring, Continue study to settle
Yeah,
whether this
yeah,
thing is
you know.
in compliance or not. Serious.